So in clinical negligence, it can be a whole wide-ranging set of circumstances. So for example, you could have a delay in diagnosis of a condition, and you could have a failure to give timely treatment. You could be dealing with a case where somebody's had surgery and actually that surgical procedure hasn't gone the way that it should have done. Sometimes I act for clients who have been injured at birth, and usually those circumstances are when the mother goes into hospital to give birth and there can be a delay in delivering the child, and that sadly means that the child then has a brain injury. I never really intended to become a clinical negligence lawyer. I actually couldn't decide when I left school whether I wanted to be a teacher or whether I wanted to be a lawyer, and I thought, well, the easiest way to find out what it's like in a law firm is to work in one. So I got a job as the office administrator now 23 years ago, and I then decided to qualify into law. I was put in the clinical negligence team just because there was a vacancy, and it grew from there. And actually now I wouldn't want to do any other area of law at all. I love the work that I do in clinical negligence. I think it's about feeling as though you are able to make a difference, and I genuinely think that we do make a difference. I know what people go through when they're bringing clinical negligence claims. I know how frightening the process can be, and I think even in circumstances where you're not able to continue with that claim, you are able to say to your client, look, this is what happened, this is the reason for your injury, and I think that helps your client have closure, and I think that's sometimes just as important as the compensation that we get. We are often instructed when the client has concerns about what's happened to them, either with the GP, the hospital, and we listen to their story. We then take a view about what we might need to prove, and the first step is to get the medical records. So once they're with us, we review them, they're all in order, and then we need to involve the medical experts. The medical experts that we instruct depend very much on what we think happened and what the outcome was, but usually we need several independent medical experts who will then look at what our clients are able to tell them. They will look at what happened according to the records, and they will be able to tell us whether they think that there is a case to proceed with, and if so, then we have to look at what the impact of what we say went wrong has had upon our client. We need to look at what the client's needs are going forward, so we will obtain medical evidence to consider whether they need treatment in future, whether they have care needs, whether they need specific aids and equipment. Sometimes they need accommodation, and we use medical experts to help us with that. And once we think we know what the claim is worth, we will try to bring the claim to a conclusion. It's not always possible to do that through negotiation, and sometimes we need to issue court proceedings and move the case on to working towards a trial. But in my experience, trials are really rare, and I think that's one of the things that clients find most intimidating about bringing a clinical negligence claim. I think it's about knowing the detail of what happened, and that detail can come from the medical records, it comes from your client's history, sometimes it comes from witness evidence of family and friends who are there at appointments which your client has concern about. It's also about instructing the right medical expert, and we have lots of experience in knowing who is best placed to comment on the client's case. I think it's really difficult to try and explain causation to clients, so that's where we've got to show what the consequences of substandard care is. So sometimes you say to your clients, well, actually we can show that the hospital, the GP didn't do what they should have done, but we can't show that it made a difference to you. And I think that's really difficult for clients to get their head around. So it's important that we have medical evidence to talk about what our client's condition is now and how they're likely to be in future. And sometimes that means that we need expert evidence on accommodation, on aids and equipment, on future therapy. And we then try and establish what we think we need to make sure that that client is protected in future. In terms of compensation for pain and suffering, then there's a number of different ways that we can look at how that's valued. So first of all, there's something called the JC guidelines, which gives a tariff in terms of the nature of the injuries of your client. And then secondly, we look at what cases in the past have settled for if there are close similarities with that and our client's injuries. Medical experts in cases like this are key because it's those experts who can tell us what the standard of care is, what the harm is to our client, and also what the client will be like in future. And I think it's important to address any outstanding issues with your expert. Your client may say, well, I've got concerns about this. And it's important that I think you're able to address any concerns with your expert. Sometimes we have case conferences, so you get all your experts together, you instruct a barrister, you have your client present, and that really gives you an opportunity to go through and look at the evidence and see exactly where you need to be heading next with the case. I think it's important to have the benefit of other legal professionals around you. So we're lucky at Slater & Gordon that we have such a wide-ranging team in other areas of law. So you know that if your client, for example, had an employment issue because of what happened to them and their injuries, you can then lean on your colleagues and say, we need your help. We need you to try and help us get this client in the position that they need to be in. The problems that clients face before they come to us is they don't know why they're in the situation they're in. And I would say the first port of call is probably speaking to your clinical team and speaking to the doctor who are treating you and trying to establish what went wrong or why you're in the position that you're in. And I think those answers are really important. I think if you're in a situation where you can't discuss it with your clinical team, then there are routes you can make a complaint if you feel as though something really has gone awry and you need to make a complaint, then there's routes through that. I think if, having exhausted speaking to your treating team, speaking to the hospital, the GP, and seeing whether a complaint can resolve it, if you're still unsure and you feel as though your questions haven't been answered, then my advice would be to consult a law firm and speak to clinical negligence lawyers. Tell them your story and see whether they can help you get the answers that you need. I think it might not be your first thought, but if you reach out to local charities who may deal with your particular condition, potentially in your own local area, you'll probably find that you come across other people who have suffered with similar injuries, conditions as you. And I think sometimes speaking to somebody who's been through what you've been through can really help. I think it's important to recognise what your client's needs are, and in the past where I've had admissions of liability, so the defendants have said, yeah, we admit that we are liable for your client's injuries, we've been able to get interim payments, so that's a payment up front of compensation, and that's really crucial to your client's recovery. In the past, that's aided my clients to put a care package in place. It's helped them to buy equipment that they need. It's helped them to have therapy while the case is still going on. I've seen clients, particularly cerebral palsy clients or those with brain injuries, and I've been out and seen them at home, and the way that they try and deal with the situation they're in, often in really unsuitable accommodation where there just isn't the space for the equipment that they need, just tells you that what you really need is to try and secure an interim payment so that you can make improvements for your client, for the quality of life, so that when the case comes to an end, you've already made a start in making that difference. What I'd want from a clinical negligence lawyer if I were in the shoes of my clients, is somebody who they can talk to, who they can ask to explain the complexities of the law, and I feel as though I'm able to do that in a way that my client understands. I don't think there's any benefit to sitting and speaking to a lawyer who's going to rehearse the law at you. I think you need it spelling out in a way that is helpful to people that don't do this every day. I always say to my clients, I know I do this every day, and I know this is second nature to me, but I understand that it's second nature to you. I think the advice I always give my clients when we start out with any claim is, you can ask me any questions that you like. You don't need to feel as though any question's a daft question, because it's my job to make sure that you understand the way that this process works.